Maine is a state that balances respect for property rights with genuine concern for tenant welfare, and its habitability laws reflect that balance. If you're a landlord in Maine, your primary reference is Title 14 of the Maine Revised Statutes, Chapter 710, the Landlord-Tenant Provisions, along with the Maine Warranty of Habitability Statute found in Section 6021. Under Maine law, every residential lease carries an implied warranty of habitability that cannot be waived. Section 6021 makes this explicit. The landlord warrants that the dwelling is fit for human habitation and that the landlord will maintain it in that condition throughout the tenancy. No lease provision can eliminate this obligation. Specifically, Maine landlords must maintain the structural components of the property in sound condition. Keep the dwelling weathertight, including windows, doors, and roof. Provide functioning plumbing with hot and cold running water. Maintain safe and adequate electrical systems. Provide heating facilities capable of maintaining a minimum temperature of at least 68 degrees Fahrenheit, critical during Maine's long and brutal winters. Install and maintain working smoke and carbon monoxide detectors. Keep the property free from pest and rodent infestations. Maintain common areas in a safe and clean condition, and comply with all applicable building and housing codes. What's interesting about Maine is the state's specific attention to seasonal issues. Maine winters are harsh, and the law takes that seriously. Beyond heating, landlords are expected to address issues like ice dam prevention, snow removal from common walkways, and ensuring that pipes are properly insulated to prevent freezing. A burst pipe in a Maine January isn't just property damage. It's a habitability emergency that can make a unit unlivable in hours. Maine's tenant remedy process begins with written notice. When a habitability issue arises, the tenant must notify the landlord in writing. The landlord then has a reasonable time to make the repair, and what's considered reasonable depends on the severity. For emergency conditions like heating failure or a major water leak, the response time is essentially immediate. For non-emergency issues, courts generally allow 14 to 30 days. If the landlord fails to act, Maine tenants have several powerful remedies. They can pursue a claim for breach of the warranty of habitability in court and seek damages including rent abatement, a reduction in rent reflecting the diminished value of the property during the deficient period. They can report the issue to local code enforcement, which can inspect the property and order corrections. They can seek injunctive relief, a court order compelling the landlord to make repairs. And in cases where conditions render the property substantially uninhabitable, they can terminate the lease. Maine also recognizes the defense of habitability in eviction proceedings. Under Section 6002, if a landlord files for eviction and the tenant can demonstrate that the property has unresolved habitability defects that the landlord knew about, the court can consider this as a defense. This is similar to what you see in Massachusetts and is a powerful incentive for landlords to address maintenance issues before they escalate. One area where Maine has been increasingly active is energy efficiency and weatherization. While not strictly a habitability requirement, the state encourages landlords to participate in weatherization programs, and some municipalities have begun incorporating energy efficiency standards into their local housing codes. Given Maine's heating costs, a well-insulated and energy-efficient property isn't just good for compliance, it's good for tenant retention. Maine's anti-retaliation statute is found in Section 6001. Landlords cannot increase rent, decrease services, or initiate eviction proceedings in retaliation for a tenant making a good-faith habitability complaint, contacting code enforcement, or exercising any legal right under the landlord-tenant law. The protection creates a presumption of retaliation if adverse action is taken within 6 months of the tenant's protected activity. For the complete guide to Maine habitability laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel so you stay informed on every state's requirements.